The Employment Rights Act can be considered one of the most revolutionary pieces of Barbados legislation within recent times. You should be aware of some of its provisions, including the right to a written statement of particulars of payment and the right, where employment has ended, to a certificate giving specific information about employment, as well as a statement giving the reasons why an employee has been dismissed.
The Employment Rights Act states that it's an offense basically to dismiss someone unfairly, and it outlines a number of categories which will be considered to be unfair dismissals. The list includes dismissing persons based on gender, based on refusing to do an act which is considered to be dangerous to their self, based on if they've contracted HIV or any other life-threatening diseases, if the person was on certified sick leave for less than 2 years, if they are on national duty, or if they have joined a trade union or a safety and health committee. So there are different aspects. Also, if the employee makes a complaint to the Labor Department regarding their employment. They have remedies in place, which includes reinstatement, whereas the person would return to the job as if they had never left. Re-engagement, where the person can return to the job, not necessarily in their same position, but they return to the workplace. Or compensation, where they're compensated for the years of service and any other monies which they may discuss. They are supposed to appeal to the employer in writing within 7 days of, or sometimes 5 days, of getting the particular sanction. The employer is supposed to have a meeting with the person to discuss their appeal and see if it can be rectified. If it's not ratified at the level of the employer, the person can come here. If it is a case of termination, the employee can visit the Labor Department after they have appealed to the employer, and there would be an investigation at the level of the Labor Department wherein we contact the employer. If that is unsuccessful, then we go into a conciliation meeting where we have the employer and the employee and their representatives here to discuss the termination. In the conciliation meeting, the department does not give out what the solution is supposed to be, but we allow the two parties to discuss and see if they can have a resolution on their own. If that is unsuccessful, then the next appeal process will be at the level of the tribunal, where the Labor Department sends on the correspondence to the tribunal for the matter to be heard before the Employment Rights Tribunal. The Employment Rights Act requires both the employer and the employee to give notice for termination. If the employee intends to resign, the Act states that they are supposed to give notice of the resignation based on how they are paid. So if you're paid on a weekly basis, then you're entitled to give 1 week notice. If you're paid fortnightly, you're supposed to give 2 weeks notice. And if you're paid on a monthly basis, then you're supposed to give 1 month notice. The notice does not increase with the length of service that the person has put in. That's for the employee. Whereas for the employer, it varies a bit based on the length of service. And it starts at 1 week if the person has worked for 1 year or less than 2 years, then it's 1 week notice that they're supposed to give if they're paid on a weekly basis. So for a weekly basis person, there is 1 week notice for less than 2 years. It is 2 weeks notice for less than 5 years. 4 weeks notice if the person has served 5 years but less than 10 years. 6 weeks notice if they've served 10 weeks but less than 15, and 10 weeks notice for 15 or more. That's for a weekly paid person. Now for a fortnightly paid person, it starts at 2 weeks, wherein they're they're supposed to give, the employer is supposed to give 2 weeks notice for less than 2 years. And then it would increase the 4 weeks for for 5 years and more, 6 weeks up to 10 years and more, and the 10 weeks, 15 years and more. For a person who's paid on a monthly basis, it starts at 1 month. So for persons working for less than 10 years, they're all entitled to a 1 month notice. Persons over 10 years, they're entitled to 1 month and a half. And for the persons working more than 15 years, then they're entitled to 2.5 months notice. The employer is supposed to consult with the employees before undertaking layoffs or short time. Short time is considered when someone is working for less than half of their earnings. So if the employer is undertaking layoffs or short time, then there's a process that the employer is supposed to follow. He's supposed to consult with the employees at least 6 weeks before the actual layoffs occur. He's supposed to outline the method and the process and how you will select the persons if you're doing last in, first out. If it's a case for the special services that you will need, you may need the cup, but you may not need the waiter, stuff like that. Or if it is a case where you're looking at performance. So they're supposed to outline the method under which you have selected the employees to be placed on the layoff or the short time. Additionally, you're supposed to give the employees in writing the notice of the layoff, as well as outlining the process. The National Employment Bureau, which is a section of the Labor Department, has in place a retraining program wherein persons who have been terminated or out of a job, once they go to the National Insurance for Unemployment, then they are referred to the National Employment Bureau, wherein they can select courses that they would want to do. This is done to assist persons to be retrained in other areas, to assist them in having a greater advantage in getting a job. So that is one thing that we do. We also offer counseling, and we provide services for writing CVs, assistance in CVs and stuff like that. So we provide employment counseling as well as assistance in CV writing.
Get to know your rights under the Employment Rights Act. Contact the Labor Department at 310-1500, email labor@labor.gov.bb, or visit the website www.labor.gov.bb. It's your right to know. You should also know about the new Shops Act, which contains a number of changes. For instance, these changes will now be applicable to cinemas, barbershops, betting and gaming shops, laundromats, and floral arranging shops.
Previously, the Act indicated that a closed day was a bank holiday, and then it specified certain days which people refer to as religious holidays. This Act now says that a closed day is no longer what would have been a bank holiday, but a closed day now would be Good Friday, Easter, Christmas Day, and Independence Day. So that is one of the changes from the previous Act. The extension of hours. This Act allows for a shop to be open from 7 o'clock in the morning on Monday, and that could go straight through until 10 o'clock at Sunday night. Previously, the opening hours were 7 in the morning to 10 at night daily, right? But now you can run straight through. Another thing that was changed in this act as far as terms and conditions of employment is the question of double time. Now, double time is to be paid for off days as well as bank holidays. So that is a new piece that is in there. I would just remind persons that right now the minimum wage for shop assistants is $6.25 an hour, $50 a day, and $2.50 a week, right? But the double time for work on public holidays and work on off days, if a person is called out, that is double time. Persons working at night then should obtain a certificate from the Labor Department for doing night work. And what we have to be sure of is that there's adequate transportation for persons to and from work, and that their safety is important, and therefore there are sufficient safety provisions provided by the employers, safety, security, so that persons coming off from work after late at night would not have to find themselves in particular difficulties. So those are some of the things that have been changed as a result of the act. Now, the penalties. The penalties have been increased, and most of them are $50,000 if you're convicted for some of these offenses, and it's $50,000 or imprisonment for a year, or both. In this night is defined as the hours 11 p.m. to 7 a.m. So that is defined as night. And therefore, as far as the transportation is concerned, the onus is on the employer to ensure that they provide transportation if adequate public transportation is not available. So therefore, if the last bus has gone and that kind of thing, then the onus would be on the employer to ensure that they provide transportation for workers to and from when it comes to night.
Employers are advised to consult with any labor officer if they have any concerns or queries regarding the changes to the Act. Likewise, employees are encouraged to do the same.
The point is that we can be able to go and do the inspection, and the employee would have no fear, because we go in and we do the inspection and we do not call the employee's name. So there's no fear on the part of the employee in drawing these kind of things to our attention.